Mr. Waldinger.
Here.
Like I said, Ms. Corbel and has not responded back whether they'd be here, but I'm assuming they're not. And Mr. Mills said he's probably not going to be here.
Understood. Approval of minutes from the July 10th, 2025 meeting. Any commissioner comments on those minutes?
Yeah, there was an error right off the bat. I did not chair that meeting, so I strike the first sentence.
I believe that was,
Jeff, right?
yeah, Commissioner Mills.
Other than that, looks good to me. With that correction, I'd make a motion to accept the minutes.
I'll second.
Motion, seconded. All in favor?
Aye.
Aye. Any comments from the public for items which are not on this evening's agenda? Hearing none, we'll move on to, there is no old business, so we're on to new business. Mank Subdivision, Plan Number 2.
Thank you. This is actually a part of another development that we've already reviewed. Just kind of a quick history of where we're at here. This parcel or this project that we're looking at here is Lutz Farm, which was originally proposed as a single subdivision. There were some complications to doing that, so it was broken into two phases, Phase 1 and Phase 2. So Mank Subdivision Number 1 went through the process, and in June of 2025, it was approved. That subdivision created a number of lots, actually created 4 lots, plus an additional lot called Parcel A. Parcel A was to be further subdivided as part of another subdivision at a later date, which brings us to Mank Subdivision Number 2, and that is that re-subdivision of Parcel A into 4 additional lots. So the existing development is a vacant parcel, semi-vacant parcel that has some fields and wooded areas on it. It's approximately 20 acres in size. It is surrounded by single-family homes on all sides of the lot in question. The topography is a sloping, moderately sloping site, generally sloping from the north down towards McCombs. There is a stream located, you can see in the black dash line here, running on the western side of the property here. Access to the site is primarily from McCombs Road. However, there is an agreement with the Timberlake Development to access Shady Crest through one of their open space parcels known as Parcel P. So the proposed development is proposing 4 new lots. They range in size from 1.8 acres up to 13 acres. Access for 2 of the lots, lots 5 and 6, will be off of McCombs, and then the 2 smaller lots, 7 and 8, will be accessed through Lot P, which is this tiny sliver of land, up to Shady Crest here. Stormwater will be handled by each individual lot, and each individual lot will design a system at the time of building permit application. And in terms of sanitary sewer service, there is an easement that runs between lots 7 and 8 down to McCombs, which will then handle the laterals for those 2 lots. So in terms of reviews, there's only a handful of comments left. They're all minor comments, all of which are addressable. 2 items to note in those comment letters. We do need a modification from the Subdivision and Land Development Ordinance, and that is being requested to allow the creation of lots 7 and 8, which will not have frontage on a street. They are primarily getting access, again, through an easement on an adjoining parcel. The other item is to show on those lots 7 and 8 and Parcel P where that access point will be, or provide us with evidence that the Timberlake Development has no issue as to where the location of those future driveways may be. So again, from a staff recommendation point of view, we're looking for 2 motions from the Planning Commission. First and foremost, we're looking for a recommendation on the modification to the Subdivision Land Development Ordinance. Staff is recommending approval of that, since that would just be for 2 lots, and it would be for driveways for those 2 lots. And also, we're recommending approval of the plan itself as the second part of that motion, And we would request that the following conditions be included in that motion, which would be resolving any outstanding issues that Gateway Engineers and myself have, which again were minor in nature, or any other conditions you may come up with tonight. So with that, I turn it back to you. And I know the developer has a representative here. He probably has some additional information they'd like to provide.
Question,
Sure.
who owns parcel P?
So parcel P is owned by the Timberlake Homeowners Association.
Okay.
And my name is Stephen Victor from Victor Wetzel Associates, and the applicant has already purchased an easement through them from the HOA that was purchased several months ago.
Can I ask a question on that? Is that easement for anywhere on the parcel?
Correct.
Could you-
There was not a restriction, primarily because we really don't know
And that's what I
where
figured.
the house would be situated, nor the type of house and what type of access they would have. When we come back in for a building permit, it would identify that. I'm assuming that could be made available to staff if you had comments or something on that. That's not something the developer will be directly involved with. It would be whoever is going to be building the home on that.
So
Can we see that on plan view, please, where parcel P is and where the easement's been granted or purchased?
Parcel P runs from here to here. It's approximately 60 foot deep, and I would describe it as a spike strip. At the time this was done, there was uncertainty by that developer, and that developer didn't want, I'm anticipating this is what happened, that developer didn't want to give access to this property, and so they put a 60 by, and this is about probably 200, 250 feet long strip between the road right-of-way and the property line to control any access through that. Therefore, we went to the HOA and purchased that right. Then the HOA discovered that they didn't have the right to do so, to just make that granting until the township had signed off. So we spent probably, I don't know, 8, 10 months sort of going through that, proving title, et cetera, and the township council did grant that right, so everything is in order relative to that.
And that looks like it's a cut slope or a fill slope down into this property?
What happens is you have Shady Crest. The parcel P rises up about 10 to 12 feet in height, and then on the backside of that it drops back down in a gradual slope. So the expectation is when someone builds the driveway, they will cut a slot in that slope and to get back into their property. And because it goes up and drops back down, and by cutting through it, it's really going to be a very gentle access into the property itself.
And the quality easement allows the entirety of parcel P to be utilized or graded or disturbed for, because it's difficult to understand what the impact may be today without having a plan view.
Right. There were no restrictions from the HOA as to the amount of cutting and grading that would take place. The easement also allows for utility access because water, gas, and electric are also on Shady Crest Court. Sanitary sewer is not, so the agreement again allows for extending of those utilities into serve individually Lot 7 and Lot 8.
So those would be extensions from just a private utility, not public mains, through 7 or 8 to feet 5 or 6.
That is correct. It's limited as a single lateral for each lot. Lot 5 and 6 will be getting their private utility type connections off of McCombs Road. There was one incorrect statement in Mark's presentation that I'd like to point out. So if we could, this slide will work. The statement here is slightly incorrect, is that the sewer authority would not like to see a lateral this long to serve Lot 7 and 8. The plan that you have shows from KDH engineering, a sanitary sewer will be constructed from the sewer on McCombs Road up and terminating at this point right here, and that's public sewer to be constructed by the developer. Off of that, it will lateral into 7 and 8. It also, because it's constructed to this point, will also a lateral will be provided to lot 6 and to lot 5. So the sewer doesn't have to serve 5 and 6, but because of convenience, it's right there. And that's the reason it runs the property line here. To be able to do that, the reason it curves off here is that you would see some existing trees. So it sort of goes around the trees and likewise goes to a point that could serve 7 and 8.
Thank you.
So going back to parcel P, the developer just purchased an easement?
Yes.
So they don't, who owns P?
The HOA.
So so the easement is in perpetuity?
Yes.
So that whoever buys and builds on lot 7 and 8,
Their deed would say they have a right of easement for purposes of utilities and access.
and their driveway will be on the parcel P property. So if something would happen, like, you know, a landslide or some disturbance, who's responsible? Would the HOA have to remedy?
Without having the easement in front of me, I'm not sure
Yeah.
who's responsible. I
There-
don't know if you
There
know.
were no provisions for that type of event to take place. Given the topography that's there, the scenario you have painted is highly unlikely. Leslie, being the attorney that she is and specializing in land use, could probably tell us the correct legal opinion, but in our opinion, we believe that all rights are given to those lots, but also it carries with it all responsibilities
Is there a width on the easement, or it simply says across parcel P?
across.
So it could conceivably be the entirety of the parcel.
It did not restrict, because you might put the driveway in one location and you might put the access to utilities in a slightly different. It's highly unlikely, because once, as I talked about it, this is a 10 to 12 foot high berm. Once you cut through the berm for the driveway, which you must do, well, it's logical that's where your underground utilities would run also. So,
Mark, I have a question, and I'm just speaking for myself. Can we limit any further subdivision on lots 7 and 8 as a covenant or a condition?
Only if the owner is willing to accept those conditions. We can't force that.
Okay.
I don't have the
I'm just
easement. I think it's a good question.
Just a question.
I don't have the easement agreement, but I think the agreement was specific to limiting it to lot 7 and 8, 2 lots. So I think the agreement is self-evident, but if it's more comfortable to make that as a note of restriction on the plat, we have no problem with that, because that was the agreement we have with the HOA, was just 2 access points alone.
I'm just thinking about the neighbors on Shady Crest, you know, thinking, well, 2 families is okay, 4, you know.
Yeah.
It's more of a understanding.
I think that
situation.
that sentiment went into why they were agreeable to doing 2 as opposed to making it unrestricted,
Yeah.
because we have significant enough frontage.
But you have enough, you have over 100 feet on both, which could indicate a flag lot, so
Yeah.
that's why I threw that out there.
Yeah. Didn't think in terms of a flag lot, but yeah. And the site is well suited for 2. It would not be well suited for more, so we're quite comfortable with that. If that's in your motion, we'll be happy to add that to the plan.
Stephen, one thing to add is...
Would you please come up, sir?
Come on.
And state your name and address.
My name is Dan Lutz. I'm one of the owners of the property. One thing I wanted to add is when we spoke to the HOA, my brother and I, they did ask us, would there only be 2 houses there? And we did assure them, I don't know if it's in writing, but we did assure them that's all that we were
I
interested
thought it was in the agreement, but whatever. We'll
Okay.
put it on the plat, and that'll finish it.
Thank you.
That'll put the nail in that coffin.
Any other commissioner comments before I solicit public comment? Anyone here like to speak on, anyone have comment from the public? Very good. And just to be clear, this is a recommendation for a subdivision, so there's no land development, there's no grading, no stormwater included with this application today. That'll come later when the homes are sited and developed and we have formal plans. Correct.
Yeah.
This is just a property line adjustment and
Yes.
subdivision.
Any developer's agreement, et cetera, for the land development portion of this is with the Peters Creek Sanitary Authority. So we will have a sort of a land development, but it's simply just to install the
sewer.
sanitary sewer.
Understood.
Yes, sir.
Thank you. If there are no more comments, may I have a motion?
Is there one or 2 motions?
There are 2 motions.
There's 2 motions, so
This will
what
be
we're
the-
looking for is the first on the modification to allow the 2 lots, lots 7 and 8, to be created with essentially landlocked lots. And then the second motion would be for the actual plan itself. And the conditions for the plan are listed there, although C would be adding that note regarding further subdivisions of lots 7 and 8.
And that would typically be on the, would that be on the modification, or you want that on the second motion?
I'd put that on the second motion.
Okay.
So should we make a motion on the first one?
Yes.
Vote?
Yes.
Then we'll do the second one
Yes.
and vote. 2 separate votes. So I'll make a motion recommending that item number 1, the modification from the Saldo allowing for lots 7 and 8 to be created without direct frontage on the street be granted.
I second that.
All in favor?
Sam.
Aye. And the second motion?
And I'd like to make a motion that we recommend this plan be approved, conditioned upon the 3 items that the staff has indicated, as well as a 4th item that no further subdivision can occur on lots 7 and 8.
I'll second.
All in favor?
Aye.
Very good.
Thank you very much.
Mhm.
Do you think these will be at council at the end of the month? Let me know when you want us to show the council.
We would probably need plans. Let me just get back to you on that. I gotta figure out when we need plans by.
Okay, thank
Which
you.
doesn't sound like there's much to change.
That brings us to the mixed residential overlay zoning district rezoning ordinance.
Yes, what you have in front of you is a proposed rezoning for several properties along East McMurray Road, just north of here. The ordinance itself specifically is looking to rezone 14 properties to remove the mixed residential overlay zoning designation, which would then leave them as low-density residentially zoned properties.
Mark, would this include 640 East McMurray that we
Yes.
discussed at last month?
Yep.
Okay, thank you.
And actually, we'll talk about it right here.
Okay.
So again, this is in the 600 block of East McMurray. Just a little quick history. Roughly 2016 was when this property was zoned to mixed residential overlay. When I say property, I mean the area, these 14 parcels, including 640 East McMurray. Later on, fairly recently, the owner of 640 East McMurray submitted a request to convert their single-family home into a 2-unit multifamily residence. We did review that and denied the plan back in July. Shortly thereafter, the council heard some comments from residents and moved to basically rezone that property as well as all the adjoining other properties in the area that are zoned mixed residential overlay. And they're looking to remove that zoning designation, which would leave them as low-density residential. Now, I'll also point out that as of Friday, this past Friday, the owner of 640 East McMurray did resubmit plans, and they will be reviewed under the mixed residential overlay because they have submitted those plans ahead of this zoning ordinance.
Mark, may I ask, was the zoning ordinance amendment advertised prior to the resubmission?
It was not. It was advertised as of Monday, the 11th.
Thank you.
And what's our charge? To make a recommendation to council that this be denied or proposed?
Correct.
And then after that, separately, we consider the new plan from 640, and if it were to say be denied, they wouldn't then be able to resubmit because the zoning would have gone through.
Correct.
Eventually, okay.
So just,
Go ahead, sorry, go ahead.
sure.
I was going to say, is there anything further?
I have a couple more
Presented to
slides.
council?
if you-
By all means.
Just give you an idea of what the area is in question to give a little bit better perspective. It's right here in front of me. So we're sitting at the bottom of the screen here. This is the middle school, and the orange hatched area on both sides of East McMurray Road is the area that's currently zoned mixed residential overlay. It's 14 parcels. They're single-family homes, and they measure about 20 acres in size in total. And of course, they range in size from anywhere from a half acre up to 3.7 acres. Surrounding the area is primarily single-family residential to the north, the east, and somewhat to the west here. But to the south, you have some town center, and town center is a zoning designation that allows for a mix of uses. So what this means for the property owners in the area under the primary items would be that the density would change. So the existing mixed residential overlay permits up to 6 dwelling units per acre, whereas the proposed low-density residential would only limit 1.2 dwelling units per acre. And of course, along with the higher density comes smaller setbacks and greater lot coverage. So through the rezoning, we would actually be making the area less dense potentially. The other item to note is that the permitted land uses would change. Under the existing zoning, you're allowed to do a number of different types of residential uses, including single-family homes, townhomes, duplexes, and multifamily dwellings. Under the proposed low-density residential zoning, you're primarily only permitted to do single-family residential. So it is staff's recommendation that Planning Commission recommend to council the approval of the rezoning as is depicted here in Exhibit A. Staff believes that the mixed residential overlay as it was crafted does not address what the intent of the comprehensive plan was for this area. And by rezoning this would remove any of those unintended consequences that we might have with development in that area.
Maybe it's in here somewhere, but what was it previous to the mixed residential overlay?
Previously to that, it was R1, which is the predecessor to low-density residential. R1 was basically a half-acre minimum, single-family detached housing.
And since most of the proposed would be quite different, it would make several of the houses probably non-conforming, right? I mean, that doesn't make any difference.
You mean
but just
if we were to do the rezoning?
Yeah.
If we're to do the rezoning, since they're already single-family homes, those are permitted in both the mixed residential but also the low-density residential, so they do not become non-conforming for the most part. They may have some dimensional area issues. I didn't actually go and look to see if
Yeah.
there's setback.
That would be going in the weeds for sure.
Yeah.
I just was curious.
So of those 14 lots, by changing it, we wouldn't have to grandfather anything?
The only thing we might be grandfathering would be some dimensional issues, and really it's going to be on more the, I guess that'd be the eastern side here. I'm not sure how wide these lots are, but we have a 15-foot setback in the low-density residential. Some of those might be close, but there'd be minor nonconformities, if anything.
None of which violate the spirit of the low density, correct?
Correct.
Yeah.
Any other commissioner comments before we take public comment? Excuse me. Anyone from the public like to speak on this matter? Sir, please say your name.
I'm Sean Crean, and I own the 640 property, 640 McMurray. And so my first question is, there's a lot of comment about the spirit of what it was zoned multifamily for. Could somebody shed light on what the spirit of what it was done for in 16 and then in conjunction with the comprehensive plan that didn't change it in 22? Just curious, like what's the spirit of it and why did it happen and why are we changing it now?
You're asking what the spirit of the comprehensive plan?
It was obviously zone multifamily, 2016. We did a comprehensive plan, didn't change, it stayed that way. So what is the spirit of it for why it happened in the first place that we're now contemplating the new, that it's not in the spirit of what we're after now? So I'm asking, why was it done in 2016?
Do you have any history of that?
I don't know.
Basically, what that area was intended to be was developed all, several parcels combined and developed more comprehensively. And also those parcels, it was envisioned that this would be more of a mixed-use style development, smaller homes or smaller lots with a number of different types of homes on it, whether they're townhomes, duplexes. It was not envisioned to just convert one house after another. But it was envisioned for a denser development than what.
I think it was a more large multifamily development or town center that would be, the catalyst would be the old middle school.
Right.
Would be, that would one of the key parcels that would then expand.
That makes good sense, right? Like, I kind of get that's the spirit of it, and it's unfortunate it didn't happen. But some of us bought property with the expectation that that could happen, including myself, right? I don't know, I can't speak for anybody else, but I bought that property because it was zoned multifamily with the intention to comply with the vision of a grander parcel. Talked to Ed Zook about it back in the day, everything else. And so here I am. So that's point number one is, I'm here because I bought it in the spirit of helping the township achieve what the vision was at the time and, starting the process like a good steward of development. So that's one point. The second point is this particular parcel had an as-built architected duplex on it, right? And so it has 2 front doors, 2 kitchens, 2 living rooms, 2 living spaces. It was built in 1950 as a duplex by the family. And so, given that, and given that it was in a multifamily, I didn't think there was any jeopardy that this would be even an existing compliant use. Hence, the investment in it was kind of easy as a placeholder to try to accumulate more of these properties in order to achieve what the vision was of myself and the township. So that's my comment.
I appreciate that, sir. Any other public comments?
Sure.
Please state your name and address.
I live right next door to the property at 642. I do appreciate what he said. However, if we do go back and if we do say the spirit of the property, that's one of the other neighbors. That was our understanding. It just appears that this was rezoned prematurely. It sort of cart before the horse, if you will. It probably would, in hindsight, would have been better if there would have been someone interested in then changing the zoning, because the intent was to develop the whole area, which we discussed, to look like maybe a Mount Lebanon area. If you're familiar with the Dublin, Ohio, something as such. And that all was predicated upon what happened with the middle school. So with that in mind, when this house did sell, I believe it was a couple of years ago, the neighbors did tell me that a developer bought it. I've been trying to be in contact with the, I believe it was Mr. Zook at the time. It just, hey, I don't think anyone's interested in one property here being rezoned. That was not the intent of what was to happen here that we all knew of. And boy, can someone help and tell us if we can do anything about this. And that started a couple of years ago. And the fear was we would be in the situation that we're in now, that we would have one home and a bunch of single-family homes that would turn into something other than a single-family home. So while we do understand moving forward and the township growing and whatnot, at some time, it really doesn't appear that the way to do it is one property at a time and just modifying that property. And another thing about when the home was originally built, it was always a single-family home. They did have a grandfather, and, I mean, there was the same family with the grandparents in it. But other than that, it was never more than a single-family home. So, other than that, I would really appreciate if we could look at what the original intent was and really start from that, because we've been trying to address this for quite some time to not get to this point. So that's all I have. Any questions I can answer if I did not articulate that properly.
Thank you.
Thank you.
Thanks.
Anyone else like to speak on this matter? Any other commissioner discussion or comments?
Oh, we have.
I'm sorry, Pam?
My name is Sarah Summer, I live right across the street. I have maybe a different point of view, like that the building codes are being followed, the roof needs fixed. I know that all can handle itself, but he used the term duplex rather loosely. I don't see it as a duplex. I see it as a grandparent or an extra unit to have family members in there. So I think duplex, maybe the definition of duplex, maybe I'm mistaken, but sometimes you can use a term just to cover yourself, but I don't think duplex is a fair way of looking at that building.
I think there's a zoning component to that where it's multifamily, duplex, what have you. And then there's a building code perspective, which this commission is not going to look at in terms of what the existing building is from a building code perspective, whether or not there was multiple adjunct family in there or not. Right,
Okay.
so I'm not sure we have that information if our code
As
officials.
far as I know from our records, is it was a single-family home. It did have 2 kitchens in it, but that was
Right.
because there was an extended family living somewhere
Correct.
else in the structure itself. But
Did it
that-
only have one occupancy permit?
It only had 1 occupancy permit.
Yeah, so I guess terminology, or and maybe I'm confusing my own issue, but, and also following code just as far as the building and structure is concerned, that it meets all the codes required as well.
I would hope that would be the case. That'd be on our building code official to kind of take care of
Yeah,
that.
and we've gone out there and inspected. There's some issues that we'll be working through with them. But that's as a single-family home. If this is to be converted to a 2-family, we will have to go through some additional building permit processes.
And also
Understood.
the occupancy permit was sort of granted, maybe the cart before the horse, as Phil said. So I think that's a consideration.
Technically, they don't have it's my understanding they don't have an occupancy permit for either unit at the
That's
moment.
I guess that's my concern too, that I know sometimes when you get somebody in, you can't get them back out, and back and forth and back and forth. So
Understood. We'll do our best to focus on the zoning here this evening.
I appreciate that. Thank you very much for listening.
Any other comments? Sir?
So I can appreciate, the complexity around whether something's a duplex or not. Given the history of, the zoning at the time and what happened in 1950, I can't speak to it. Don't know the family, don't know how it went down, but I'd invite you to go look at the listing that when I purchased it, where they offered it up as a duplex and described it as a duplex and such. And so everybody has an opinion. There are obviously, we all know the technical aspects of it. I was very aware and talked to Ed Zook immediately on purchase to make sure that we tried to go through a process. Was it, at that time. But I just want to point out that, at the time, the agent described it as a duplex and sold it with that expectation and what all the options were in a multifamily zone.
Understood. And I would just encourage anyone who's watching is to look at, the occupancy and what may be possible with a particular property, because that is a large component of it.
Yeah, which, just for clarity, that is what I did too, right? It's multifamily. I looked up multifamily, what can I do here? And, that was the whole process at the time of purchase.
I think zoning and occupancy are 2 different elements. Zoning describes what you can build in terms of the property, but then the occupancy permit describes what is actually there
That was the
that
clarity
day.
that we kind of ensued on, and that obviously how we ended up here, but
Understood.
I got it. Thank you.
Yep. Any other commissioner comments?
Question, maybe Commissioner Peters can address this, but I won't put you on the spot, is so Mr. Crehan apparently owns 640,
Yes.
and he's reapplied for a
In
Or
our
mixed
zoning, we're
residential?
calling it a multifamily residence, and it's for 2 dwelling units.
Okay, so that's traveling down that road.
Yes.
And no matter what we recommend or don't recommend, that has its own life.
Yes.
And that possibly could pass. What would this look like? And again, this is definitely above my pay grade. If that was approved and the rest was recommended as going back to the residential overlay, is it a spot zoning?
No, so
No.
it would be, the pending ordinance rule provides that if you submit an application prior to the advertisement of an ordinance change, you take subject to the prior zoning. So under a subdivision land development ordinance, you take, as of the date you submit your application, whatever the zoning subdivision or other governing ordinance is, that's what you get. With zoning, there's a pending ordinance rule, which leads to kind of the race to the courthouse to file before something gets advertised. It sounds like they filed Friday and we advertised Monday, so
Correct.
he's in.
Oh, and I get that, but
Right.
so if council goes ahead and takes it back to a residential overlay and he's in okay with the mix,
He would just become a pre-existing non-conforming use.
yeah, can he sell down the road
Yes.
as a mix? Okay.
He would still be pre-existing.
That
Well,
use
make sure
runs with the
his-
land.
Correct.
Correct.
Yes, I just want to make sure his
There
rights
are
are.
limitations on expansion.
Sir,
and that's-
yeah.
One more time. I would just like to reiterate, when we were aware that this house sold, I did call Mr. Zook and said, what can we do to try and get ahead of this? And here we are years later. I've really tried to get ahead of this, and I'm sorry we're at this point. But again, we've tried to address this because we have a bunch of single-family homes here, and everyone's desire was to keep it that way. So I just wanted to reiterate that this hasn't been something we just tried to do recently. I can go back through my phone records through several things, making the calls, trying to inform.
I think, yeah, I appreciate that, and I don't think that's in question. I think what's in question here is understanding that there are 2 applications or 2 processes that are running in parallel right now through both planning commission, staff, and council. This is but one of them. There is a valid application that's been submitted, or at least an application submitted, the validity of which is still being reviewed. The technical comments of that is still being reviewed, so
Yes.
that may or may not be before this commission before long.
Understood.
Sir?
A couple points. One, after I purchased the property, I made it clear to Ed Zook at the time as well, multiple meetings about my interest in buying additional land, talked to other people about buying their land and trying to get a bigger project done. So my intent was clearly to do that. It didn't work out that way, and it's okay. So with that said, and being respectful to, now that I hear the spirit of that was the goal, and now I hear, the people's concerns in the neighborhood, I just want to say I'm perfectly content if I only can use it as a duplex and not 6 units per acre or whatever else might come with that. If there's a grant that makes sense for you guys, it'll at least let me get a return on my investment at least without causing further disruption to the neighbors. I'd be happy with that.
I think that discussion would happen upon the application coming before this council or this commission, if it was duly submitted, correct? I mean, we're not going to really discuss the operation of your property here this evening. It's more of a
I see.
global
Got it.
rezoning.
Okay.
Yeah, is that,
But, I mean, to Mr. Crehan's point, though, if we go through with the rezoning, you have your application in, and if it gets approved, it can remain a duplex in perpetuity.
And again, you tell me, and it's not because I want it, but it's six units per acre, and I have an acre. So theoretically, because I talked about that with Ed Zook at the time, if this is all I can get, am I permitted to tear this down and put other units up and whatever? It's not worth doing to me. Obviously, I would have done it, but that's all I'm getting at is I would give up that if there's just a non-conforming use situation that makes more sense, so that it doesn't get into somebody else's hands where they get this idea. So that's all I was just being respectful for.
No, we appreciate that, and that'll be contemplated when that application comes before this commission. Yes, ma'am.
Hi, Joyce Ross, 642 East McMurray, next to the property as well. I am just asking that you please consider rezoning back to single-family dwellings. Have a lot of nice big homes. For instance, mine, I could turn into 3 houses if I wanted to if you rezone this. I don't think that was the intention of coming down East McMurray Road into the beautiful town center and to have these single-family homes chopped up into separate units. I don't recall the original plan, but I thought there was mention of a six space parking lot at 640 East McMurray. So I'm afraid that we would go past 2 families here. And again, if you do this house after house, that's not going to be a pretty neighborhood like we want on our East McMurray coming into Peters Township. So I'm asking you please to consider going back to single-family residential in this area. Thank you.
Thank you.
Thank you.
Thanks.
Any other audience comments? Commissioner comments? May I have a motion?
I'll make a motion that the Planning Commission recommends a zoning ordinance amendment to the zoning map.
I'll second.
All in favor?
Aye.
Thank you. Any other business from a staff update?
No, that's all we got for tonight.
Very good.
Now, I will note we probably have 2 or 3 plans coming at the next planning commission meeting.
Single-family land developments, or?
This one here, the 640 East McMurray, there's a, I think Water Dam Plaza, they're looking to rework that Rite Aid, the former Rite Aid that's there. And there's one other one that's slipping my mind, so.
How's the hunt for an assistant coming?
So far, so good. We have made an offer to someone, and hopefully that'll come through, and we'll be seeing them possibly at the September meeting.
Fantastic. Thank you very much. Meeting adjourned.